Good morning, everyone.
Good morning.
Good morning, Your Honor.
Morning.
Right. We are now in session in the matter of DPW Enterprises LLC and Mountain Prime 2018 LLC versus Jeremy Bass and Dwayne Pike. This is case number CV 35-24-1063. We have present on behalf of DPW, the plaintiff in this matter is Liz Stoddard, appearing by video on the Zoom session. Present on behalf of Dwayne Pike is his attorney Ken Nagy, and I think I see Mr. Pike there in the background.
Yes, Your Honor, he's here with me.
All right, and also present is by video is Jeremy Bass, representing himself. And this matter was set for hearing today on the plaintiff's motion for summary judgment. In this matter, the motion for summary judgment, along with the memorandum and 3 declarations, was filed back on September 16. Was originally set for hearing on the 15th and then reset to the 22nd, I believe, to accommodate Mr. Nagy's schedule. And then on October 1st of 24, Mr. Nagy, on behalf of Mr. Pike, filed his response and supporting affidavit. On October 8th, Mr. Bass asked for this matter to be continued, as he indicated he had needed more time to respond. There was a compromise through that hearing that where the plaintiff agreed to allow Mr. Bass an additional week to file his response, and they and expedite their reply. So Mr. Bass was given until October 15 to file his response, and plaintiff was given until October 18 to file a reply. On October 14, plaintiffs filed their reply to defendant Pike's response. October 15, Mr. Bass filed his response and affidavit and submitted a thumb drive as well. And then on October 18th, plaintiffs filed their reply and affidavit to Mr. Bass's response. And then late yesterday afternoon, Mr. Bass filed 3, I guess he calls them responses to a portion of the reply. There is no provision for there to be a reply to a reply, and and the court is not going to consider the 3 documents filed by Mr. Bass yesterday afternoon at 4:41. And so, with that, Mr. Stoddard, this is your motion, so I'll hear argument from you first.
Thank you, Your Honor. As the court is aware, the record before this court, this is a standard post-foreclosure action for ejectment. There are 2 defendants, each with differing postures in this matter. The first is Mr. Bass, who occupies the property as the former owner of that property. And then Mr. Pike is the only other defendant who has appeared, who is asserting that he is a tenant of the property and entitled to remain in that property pursuant to a executed lease agreement. Because the analysis with respect to each of them differs, I'll take each one of them separately. But the case law is clear, Your Honor, that following a non-judicial foreclosure, the successful purchaser is entitled to possession 10 days following that sale. The undisputed record before the court indicates that there was a default on a deed of trust that Mr. Bass signed that encumbered the real property, that a sale was noticed, subsequently postponed multiple times. Litigation took place between Mr. Bass and the trustee and beneficiary. That was dismissed. And ultimately, a trustee sale was conducted, was held on the courthouse steps, and a representative of my clients attended that sale, submitted the winning bid. A trustee's deed was issued and recorded in its favor. The plaintiffs at this point are making a claim to have possession of that property as against the interests of Mr. Bass and Mr. Pike because they purchased it at a successful trustee sale. The consequences of a trustee sale with respect to a former borrower are clear. It terminates all right, title, and interest of that former borrower. And again, they were entitled to possession 10 days following that sale. Mr. Bass still maintains possession of the sale, as evidenced by his pleading. He is refusing to relinquish possession. He has presented no evidence indicating any irregularity with the way that the sale was conducted by way of notice or any other statutory irregularity. Rather, what Mr. Bass has set forth before the court is a number of conclusory, I'll call them conspiracy theories, as to what he thinks occurred.
Can I object to that?
That's it's all speculation. The record before the court, including Mr. Bass's own evidence, reflects that there was a sale held. It was held outside. Anybody could attend. He hasn't presented any evidence that people were stopped from attending that sale, that people were told not to come to the sale, that people were somehow scared away from that sale. And in fact, Mr. Bass is seen in those videos, if the court reviewed them, holding a sign intended to dissuade people from attending that sale, giving some sort of indication that they might be subject to criminal penalties or jail time. Really, at the end of the day, with respect to Mr. Bass's right to possession of that property, he hasn't presented the court with any evidence indicating any statutory failure in the non-judicial foreclosure process. And in fact, the trustee's deed is entitled to prima facie presumption of compliance. And the recitals therein are entitled to a prima facie presumption of truth. That includes that a notice of default was given, recorded, that the various statutory notices were given. That would include posting, that would include mailing. Mr. Bass attended the sale, and therefore the record's clear that he had actual notice of the sale. And the law in Idaho is clear that where there are no issues regarding the statutory notice provisions, that trustee's sale becomes final. Mr. Bass has raised a number of questions regarding how the sale was conducted, and again, is alleging that there was some form of collusion, but cites no case law or support for those propositions. Rather, my client contacted the trustee in advance of the sale to find out what the opening credit bid was going to be. Credit bids have been acknowledged by the Idaho Supreme Court as proper bidding procedures for a creditor. Having found out what the opening bid amount was going to be and how those funds needed to be tendered, my client sent its own representative to that sale to bid on its behalf, where it was the successful purchaser placing the highest bid, and thus the property was sold to it. That nobody else showed up to the sale, I don't know why that would have occurred, neither does Mr. Bass, and so there is no evidence in the record that bidders, again, didn't attend because of some, I guess, alleged collusion or other price fixing or whatever Mr. Bass wants to allege. And so for that reason, Your Honor, I think the record is clear that my clients are entitled to possession, immediate possession of that property, as against any interest claimed by Mr. Bass. With respect to Mr. Pike, the analysis changes a bit. Mr. Pike is apparently a tenant of that property. Following the sale, as is common practice in my practice, we send a notice to vacate to the property. The purpose of that notice to vacate is to let former owners like Mr. Bass know that, hey, the property was sold, you need to vacate that property. But also, with respect to tenants who we may or may not know about, it is to inform the tenant of potential rights they might have under the Protecting Tenants of Foreclosure Act. The notice to vacate that was sent, Mr. Pike received. He called my office. At that point, he said, I'm here on a month-to-month lease. I'm entitled to 90 days to vacate. No disagreement there. That's what the Protecting Tenants of Foreclosure Act affords a tenant that's there on a month-to-month lease. Ultimately, it didn't make any sense to initiate two separate evictions, and so Mr. Bass and Mr. Pike both got the benefit of 90 days to vacate the property, and when they failed to, the complaint for ejectment was filed. In responding to the complaint for ejectment for the first time, Mr. Pike filed a purported 2-year lease renewal entered in prior to the foreclosure sale. I attempted to try and negotiate with Mr. Nagy on behalf of Mr. Pike, but when negotiations ultimately failed...
Your Honor, I'm going to object to any discussion regarding settlement negotiations.
I don't intend to discuss the terms, Your Honor. Just that
All right,
we
thank you.
we communicated. ultimately, when the matter couldn't be resolved amicably, it became necessary to file the joint motion for summary judgment as against both individuals. The short of the summary judgment as against Mr. Pike is that if he is there pursuant to a lease, he needs to prove that he's in compliance with that lease. And in fact, the notice to vacate that was given to Mr. Pike said, if you believe you're a bona fide tenant, provide a copy of the lease so we can evaluate it, determine if you're there, if you're pursuant to a month-to-month or for a term. Give us copies of your previous rent payments so we can determine that you're in compliance with your lease. And most importantly, and I think the issue before this court is, you need to continue to make your lease payments if you're there underneath the bona fide lease. The record before the court and the undisputed evidence is that Mr. Pike failed to do any of that, at least with respect to my client. He was informed that my clients purchased the property. He was informed and asked to send my clients a copy of any lease agreement so they could evaluate it. He was informed and asked to continue to make payments under that lease agreement to my clients as the new owners. None of that occurred. Rather, the undisputed facts before the court is that Mr. Pike elected to continue making his rent payments to Mr. Bass. Unfortunately, that he chose to pay the wrong individual his rent for the preceding 7 months does not render him in compliance with that lease agreement, especially where he seeks to have my clients bound by the terms of that lease agreement. And so for that reason, Your Honor, Mr. Pike's attempt to avoid removal from the property pursuant to a lease agreement also fails because he is not in compliance with that lease agreement, has not paid rent to my clients during the intervening 7 months, continues to not pay rent to my clients, but is instead elected to pay Mr. Bass, who has no right, title, or interest in that property. And so, again, I think the case law on that entitles my client to immediate possession of the property. And with that, if there's no questions, or if the court has questions, I'm happy to respond.
I don't have questions at this time, Mr. Stoddard, so let's take up a response to each of those. We'll start with the first argument was in regards to Mr. Bass. So, Mr. Bass, would you like to respond to that?
Yeah. By their own filing, the second declaration of DPW Enterprises, it is mentioned that they had contacted the trustees. That is a violation of the Sherman Act. That is not upheld by any court that you're allowed to, which is proofed by the fact that you put the payoff amount in the notice. That right there takes it out of, as I understand it, would cause a jurisdictional problem because federal statutes would be adjudicated in federal court, not in district court. As I stated before in earlier hearings, I was instructed to stay in the property by the prosecuting office, that there's open investigations occurring, and as far as I understand, are still occurring. And I was told by Nathaniel Rudd from the prosecutor's office to sit tight and stay in my house until there's a case that crosses his desk. As far as the lease goes, if for whatever reason I was to be found not the owner, Mr. Pike has paid his rent to me. As far as he understands, there's been, as far as I understand it, there's no reason for him to believe that there was any other owner because we got incomplete notices that were missing pieces, and that would be for the plaintiff to go ahead and prove that they had sent the notices in complete form and correct. Otherwise, we would have no reason to abide by them, because why would we believe that was, if it's incomplete, it could be anyone that could send that. For also to point is that in order to have rent or to have a tenant, you have to have the house at 68 degrees. You have to have electricity on, things like that. And there was no attempt by anyone to take those and make sure that Mr. Pike was taken care of correctly and his rights as a tenant were maintained. I paid those, and just as I paid the taxes and the insurance, which was part of the verbal agreement that I had with Carrington Mortgage, that I have both the recorded conversation from Miss Moreland, claiming that she was talking with the trustees or the bank, and that Mr. Wangsgard also agreed that he had talked to the trustees before. I think it's very clear that they had been in communication, and any communication with them would be in question of whether it be price fixing or not. I mean, you could easily just go, no, you don't really want to buy that, and leave it at that. Or, yeah, congratulations, that's going to be a great buy. Anything that's positive or negative, even if it's just giving the number, would still be price fixing, because you're steering the customers or the bidders away, and which is the legislative intent of why the number is included in the notice. Let's see, and then my attendance to the auction, I was prevented from bidding because they had already price fixed it, that they had arrangements, and because I was prevented from it, I couldn't make a bid because I would be knowingly participating in a fixed auction, which would make me party to that. So I was prevented from bidding on the house, and there's no sorry. Sorry, I'm reading my notes. As far as the awareness of property defects beforehand, it is assumed in the statutes that you have a due diligence to look at the properties, and if they talk to the trustee would have been able to tell them very clearly that there was issues, because I've made it very clear to the trustees that there was problems. So since they had called and got a number, they should have been aware of the issues, which makes them a non-bona fide buyer in that sense right there. So the fact that they called them takes them completely out of the realm of protection from the status of a bona fide buyer, because they had all rights and all ability to find out information about the property before paying for it, and which makes them knowingly participating in this with all those problems. These are I had provided the evidence of the talk with the trustees in the filings from yesterday. I understand that the court does not want to take them. Are we allowed to have the evidence put in without the declarations or the responses?
What do you mean?
Attached to each one of those there was proof. So as far as like the allegation of me misquoting things on purpose, I included a Shepherd's report that showed that the plaintiff's side had more errors in theirs, more citation errors than mine, and part of that evidence was also that there was the emails that had been sent to the trustees that made them very aware that that there was problems with the property, and so by them communicating with the trustees, it would be assumed that that they would have been aware of the issues.
Let me interrupt for a moment, Mr. Bass. When you say that there were problems with the property, what are you referring to? Was the property run down? What are their issues with the
there's several.
water? I don't know.
There's several issues with the property, with both the title and the property itself of what they were trying to sell. With the property,
it's with the title is what you're talking about.
Yes, and
not with the physical defects to the property.
The physical defects with the property are separate, but there are defects that are there that the buyer wouldn't have been known.
Claiming, I just want to clear what your argument is, because sometimes I can't follow you. Your argument is that it was because the trustees were made aware by you in emails that you sent to the trustees that you claim an issue with the title, that the buyer, in this case the plaintiff, should have been aware of those issues, and therefore because they should have been aware, they cannot be a bona fide purchaser. Is that what you're saying?
I'm saying that in order to be a bona fide purchaser, you must have you have the responsibility to know what you're buying. And
where the authority for that is.
The authority for that was listed in the filing from before.
But where is it? Are you talking a statute? Are you talking case law?
What
are you referring
to? Case law and
which case?
And statute.
In which statute?
So the statute is 55,508, I think, which says that has to be a 5508, I believe. I'm pulling up the
5508.
I believe I'm pulling up.
What title? What section?
Give me 1 second, Your Honor.
Idaho Code is referred to. You get a title like Title 55 dash something.
Yes, Your Honor. Give me 1 second. I'm just pulling up my that specific one. Let's see. Response. Okay. Let's see. I'm sorry. It was Idaho Code section 45-1508. I believe that's the title of the title for you. See, the title is 45 Liens, Mortgages, and Pledges, Chapter 15 Trust Deeds. Specifically, 1508 is Finality of Sale, which says that the purchaser must be in favor of the purchaser in good faith for value. So the purchaser must be in good faith, and so that's the defining part of the statute, requires them to be in good faith. And then case law for it. So in one who relies for protection upon the doctrine of bona fide purchaser must show that at the time of purchaser.
I'm sorry, Mr. Bass. I need you to read that very slow, much slower than you are.
Oh, I'm sorry. Sorry about that. So it says one who replies for protection upon, or who relies upon protection of the doctrine of being a bona fide purchaser must show that at the time of purchase he had paid a valuable consideration upon a belief and the validity of the vendor's claim that the title is without notice, actual or constructive, of any outstanding adverse rights of another. And that's Richard Brick Corporation versus Hearst Hardware. I'm not sure how to read the actual citation. If it's AWVA 476. It was listed in in my defendant Bass's response to plaintiff's motion for summary judgment on page 2, line.
AWVA?
I'm sorry?
What is the citation? AWVA?
The citation is Richard Banks Corporation versus Hearst Hardware Co., comma 80 WVA 476 dash, or I'm sorry, comma 92 SE 685.
Oh, that's not from Idaho. That sounds like it's from West Virginia.
And then it goes comma colon Merchants Trust versus Davis, comma 45 Idaho 494, comma 290 P dot 383
Okay, so,
semicolon.
Merchants Trust versus who?
Merchant Trust versus Davis.
Davis. Thank you.
Davis.
That's 45 Idaho 494.
49 Idaho 494.
49 Idaho 494.
Yes, Your Honor. And there's more behind it, but is that the Idaho one that you would like, or there's?
I just need to know that there is an Idaho reference.
Oh, yes, Your Honor. There is. And then
And you're saying that that case law stands for the fact that the bona fide purchaser has to show that they paid valuable consideration upon a reasonable belief that the seller had title?
that the seller had that the title was free and clear of any issues at all. That there was no claims, no issues. It went further on to say that further one who purchases property with sufficient knowledge to put him in, or a reasonable prudent person on query, is not a bona fide buyer. And that is from Foreman versus Madden, 13 Idaho 138, which is part of it. So it's, if they have reason to be on notice, which the trustees had notice. There was notice by me being there saying that there was problems at the auction, that there was on the front of the house a big 2x4 poster that said there was issues with that the property was in contention, and posted up visible for everyone to see. It'd be unreasonable to think that you would buy a property without even going by and looking at it, which they would be able to see.
Didn't you file a claim against your prior mortgage company?
I filed to,
which was dismissed? It
was dismissed for inability to serve correctly. It wasn't dismissed with prejudice. I was trying to find a lawyer to continue the process. In the meantime, I was also trying to pay off the house that they claimed that I owed in order to take that off the table, so that way I didn't have them using that as leverage against me. That's when we entered.
Wait. So you owed money on the house?
That they said. That doesn't mean that it was legit. It was just that that's what they said, and they were using that to hold to try to work against me. So
do you believe that you've paid for that house in full?
I believe that the house was paid off in full, and they agree.
What proof do you have of that?
A letter of full reconveyance.
To you?
To me, yes, Your Honor.
From whom?
From Bank of America.
And where's that in your filings?
That was not in the filing that I gave in this part. It is in it's in public record, but it's also it was from the case that was dismissed. Okay. But the other side concurred that it was legit, that it's not in dispute. That the
all right, we've gone far afield of what's at issue in this case. So you do not believe that the plaintiff is a bona fide purchaser, because you believe that you have stated that there were issues with title. All right. Anything else in your argument?
Well, and they participated in price fixing by calling the trustees that removes them out from the statute or the protection of a bona fide buyer by them contacting them and interacting with them. There's no way for, they can say that it was just to get a number, but how much of the conversation is irrelevant. The fact that they called them at all is what breaks the Sherman Act.
All right. We're going to have to move on to Mr. Nagy now because I have another hearing that's supposed to start right now, but I want to hear from Mr. Nagy. So, Mr. Nagy, in regards to the argument that's been made about Mr. Pike as a potential tenant of the property, I'd like to hear your argument.
Thank you, Your Honor, and I'll try to be as brief as possible because my argument is set out in the brief that I filed, so I don't want to repeat a lot. I just want to stress that what I think are the important points. The problem as I see it with the plaintiff's case is that they're seeking ejectment against both Mr. Bass and Mr. Pike. And I've not found any legal authority in which a tenant can be evicted through an ejectment proceeding, and the plaintiff has not cited to any authority in any of its briefs. Each of the named defendants, Mr. Bass, Mr. Pike, are in a different relationship with the plaintiff, as Mr. Stoddard acknowledged in his argument. Mr. Bass, the alleged former owner of the real property, therefore the case law that I've read indicates that ejectment would be the proper way to remove him. I'm not arguing in any way that he should be removed. I'm only stating that ejectment would be the proper process, which is what the plaintiff is pursuing. However, with regards to Mr. Pike, he is or was a tenant of Mr. Bass. Therefore, eviction is the proper method to seek his removal from the property, which is something that the plaintiff has not pled and has not done. The problem for the plaintiff in its pleadings and its arguments is that it seeks to treat both Mr. Bass and Mr. Pike the same, even though each has a different relationship to the plaintiff. The elements of ejectment are set out in numerous cases issued by the Idaho Supreme Court. First element is ownership, second is possession by the defendant, and the third is refusal by the defendant to surrender possession. Those elements are set out in numerous cases. One of them cited by Mr. Stoddard is Pro Indiviso, 131 Idaho 741. That's a 1998 case. However, those three elements presuppose that the defendant has wrongfully refused to surrender possession of the property. They therefore don't apply to a tenant who has a valid lease to the property, as in this case. Admittedly, the Idaho courts have confused the terms eviction and ejectment, and have generally, in a number of cases I've read, have used those two terms interchangeably. So I recognize that it is somewhat confusing to distinguish between the two doctrines. However, the Idaho Supreme Court has expressly held that an ejectment action, not an eviction action, is proper where the possessor of real property remains in possession after they lost ownership through foreclosure. So the court did distinguish on at least that one occasion, and that's Indian Springs LLC versus Anderson, 154 Idaho 708. And in that particular case, the plaintiff, which would be similar to the plaintiff in this case, filed an action for ejectment and then amended its petition to add a claim for eviction. And the court found that ejectment claim was the proper vehicle rather than eviction, because as the court said, eviction statute, Idaho Code 6-310, doesn't fit the facts of the case. They were seeking to remove an owner who had been foreclosed upon, and the court said, no, this is an ejectment action, not an eviction proceeding. I've not found a single case in which the court found that an ejectment action is the proper vehicle for removing a tenant, such as Mr. Pike. In this case, where the property's been foreclosed and the leaseholder continues in possession. not found a single case. So Idaho law requires that an eviction action be initiated with regards to a tenant who has a lease to property. Title 6, Chapter 3, that's where the eviction statutes are located in Idaho Code. And apparently the plaintiff realized that it did not properly plead an eviction action in this case, because it started arguing in its memorandum in support of its motion that Mr. Pike should be, quote, ejected for non-payment of rent. No court has allowed that. The plaintiff argues in its reply brief that and these issues were discussed in the brief that I filed on behalf of Mr. Pike, and in its reply brief, the plaintiff argues that those strict requirements of the eviction statute 6-303 pertaining to evictions for non-payment of rent need not be complied with because it's pursuing ejectment, not eviction. And so I think in that sense, they're mixing up those terms. But the Indian Springs LLC case issued by the Supreme Court that I cited makes it clear that eviction is not appropriate in an eviction action. So the reverse would equally be true, that eviction would not be appropriate if somebody's a leaseholder. And that's the best authority that I can find in the Idaho Supreme Court decisions that indicates that the plaintiff must follow the eviction statutes. Now, the plaintiff cannot be correct in arguing that it can seek ejectment of Mr. Pike and need not comply with the eviction statutes, because if it is correct, that means that all landlords could use ejectment instead of eviction, where somebody's got a lease to property. And that certainly can't be correct, and there's no authority for it. Now, with regards to whether the plaintiff has met its burden to show that summary judgment is appropriate in this case, it attacks Mr. Pike's affidavit, arguing that when Mr. Pike says that he's paid his rent, he's current on his rent, he paid this much, who he paid it to, he sets out all those facts, the plaintiff argues that's a conclusory statement. But I'm sure the court is aware that when the statutes pertaining to, or the rules pertaining to summary judgment say that you can't use conclusory statements, that's talking about legally conclusory, not factually conclusory. Mr. Pike has set out the facts that he has a lease, he's in compliance with that lease, he's paid the rent, who he's paid it to, how much he has paid. Those are factual statements, and those are in the record, and summary judgment ought not be issued in this proceeding, given that there is a legitimate dispute of facts in this proceeding. Your Honor, plaintiff also faults Mr. Pike for continuing to pay his rent to Mr. Bass. And that's the most curious argument that the plaintiff makes, because as Mr. Stoddard has stated, and as the plaintiff has attached to its petition, the plaintiff sent a notice of eviction and 3-day demand to vacate the property. And Your Honor, that notice is in the record, it's attached to the petition, and it specifically states if you believe you are a bona fide tenant with an unexpired lease or a bona fide tenant with an expired lease, you are required to make your required monthly lease payments during the remainder of your lease agreement. And I talked about this in my brief, Your Honor. Mr. Pike did that. He did exactly what the plaintiff stated. But Mr. Stoddard seems to think there's other instructions in there that told Mr. Pike what to do. There aren't, Your Honor. So it's curious when Mr. Stoddard argued at the start of this hearing that he said that that Mr. Pike was told in that notice to pay the rent to the new owners. He was never told that, Your Honor. So Mr. Pike did what he was told to do. He remained in compliance with the lease. He continued to pay his rent to Mr. Bass, which he was legally obligated to do under that lease agreement. So I think that Mr. Stoddard's argument falls flat, Your Honor. On the 5th page of the plaintiff's reply brief, the plaintiff refers to that provision and Mr. Pike's reliance on it. The plaintiff writes, quote, that Mr. Pike relied, quote, on a singular sentence from the notice to vacate that he received and disregards the remainder of the notice. Well, Your Honor, the plaintiff ignores the fact that that, quote, singular sentence was the only instructions to Mr. Pike contained in the notice. So Mr. Pike did what he was required to do. And of course, that argument begs the question, what else would the plaintiff have had Mr. Pike do when he was relying on the clear directive in the notice? So, Your Honor, it's odd that the plaintiff directs Mr. Pike to stay current on the lease with no other instructions and then faults him for doing that. Your Honor, it's noteworthy that the plaintiff's petition does not state a factual basis upon which Mr. Pike can be either ejected or evicted. The word eviction or evict does not appear in the plaintiff's petition. They have not properly pled their case. The rules are clear, the statutes are clear. The eviction statutes require a 3-day notice. If the plaintiff is now arguing, which they did not plead in their petition, that Mr. Pike is behind on the rent. They've only argued that in their memorandum in support of their motion for summary judgment. They've not given the required 3-day notice, putting Mr. Pike on notice that he's behind on the rent, which would then allow him to cure, if in fact he was, though that is a dispute of fact, whether he is behind on the rent or not. So, Your Honor, these facts are set out in the affidavit. There is clearly a dispute of fact in this, and the plaintiff has acknowledged that if the lease is in effect and Mr. Pike is in compliance, Mr. Pike is protected by the Federal Protecting Tenants at Foreclosure Act. So that federal statute protects Mr. Pike, and therefore, given this dispute of fact, summary judgment will not be proper. It should be denied. Thank you, Your Honor.
Mr. Nagy, I have one question. In the lease on page 5 of the lease, top of the page, condition 32.2, if the property is sold, the lease will transfer with the property and the new owner will be bound by all the terms and conditions of this lease. Why did Mr. Pike not pay the new owner his lease agreement?
Because, Your Honor, Mr. Pike was aware that the ownership of the property was in dispute, and he was concerned that if he did not pay Mr. Pike, he would be in violation of that lease. And so, where Mr. Pike receives clear directive from the alleged new owner of the property to remain in compliance with the lease, Mr. Pike believed in good faith that he had to continue to pay the rent to Mr. Pike, to Mr. Bass, I'm sorry. And so, as I stated in my brief, if the plaintiff believed that that was improper, it should have petitioned to amend its complaint to seek eviction against Mr. Pike, or to obtain reimbursement of those rents paid to Mr. Bass from Mr. Bass. And the plaintiff has not done that. Once the plaintiff was put on notice that there was a valid lease in effect, it did not seek to obtain the rental payments from Mr. Bass. And instead, it just simply argues that Mr. Pike didn't do what he was supposed to do.
And to be clear, the first notice plaintiff had of a lease was on August 14th when you filed your answer.
Well, Your Honor, Mr. Stoddard did state in his affidavit he filed 3 declarations, and they indicated that there was a conversation before I was involved between Mr. Pike and I believe it was Mr. Stoddard regarding whether there was a lease. And Mr. Pike stated that he had a lease. There's a dispute as to whether it was a month-to-month lease or a written lease. But Mr. Pike is not an attorney. He didn't know what to do. And as soon as he contacted me, I began communicating with Mr. Stoddard and provided Mr. Stoddard with a copy of that lease. So we did that as quickly as possible, but we're dealing with an unsophisticated party here, Your Honor. However, there's no statute, no legal authority that I can find that required Mr. Pike to provide that lease to the plaintiff. The Protecting Tenants in Foreclosure Act simply states that if there's a valid lease, he's protected.
All right, thank you. Mr. Stoddard, since your motion, I'll give you the last word.
Thank you, Your Honor. And I'll keep my comments brief with respect to Mr. Bass's argument. There's nothing in the record indicating any instructions from a county prosecutor, any open cases, and so that's just, again, an unsupported conclusory allegation. With respect to bona fide purchaser status, again, Your Honor, the Idaho Code delineates a difference between a bona fide purchaser for value and anybody buying at the sale. The trustee's deed is afforded prima facie presumption of compliance to everyone. If you're a bona fide purchaser for value, it's conclusive. In the reply brief, we noted that dispute that Mr. Bass wants to argue about is ultimately immaterial because there is nothing in the court record indicating any failure to comply with the Idaho Trust Deeds Act. So whether it's prima facie and can be rebutted, or it's conclusive and can't be rebutted, where there's no evidence one way or the other indicating that it wasn't complied with, and all of the evidence shows it was complied with, that's an illusory argument. And so for that reason, Mr. Bass's arguments fail. Additionally, the citation to the Appel case notes that bona fide purchaser status relies upon notice of statutory irregularities in the non-judicial foreclosure sale. That's what bona fide purchaser and status and inquiry notice is limited to. Not did I put a paper in my window saying, I disagree, this shouldn't go to foreclosure, haha, nobody can ever be a bona fide purchaser.
I object against that.
The record before the court contains the land records of
I object against that.
Which contains the deed of trust, contains the notice of default, contains the statutory required notices under the Trustees Act, all of which were recorded. The notices of postponement, again, all of which were recorded, and a trustee's deed conveying ownership to my client. As such, they were entitled to possession 10 days after. With respect to Mr. Pike, again, Your Honor, I think the simplest classification of the response is the dog ate my homework. I paid the wrong person, and now Mr. Nagy wants my client to have to go to the person that he paid erroneously. That's not the contractual relationship that Mr. Nagy wants and Mr. Pike are seeking to enforce. This was an action for ejectment against an individual occupying the property. He submitted a lease and asserts an affirmative defense that my client is required to honor that lease agreement. The burden of proof on an affirmative defense is Mr. Pike. If he wants my client to honor the lease agreement, then he needs to prove that he's in compliance with that lease agreement. He admits he is not. He did not make payments to my client. He is not making payments to my client. He has not sought to disgorge those payments from Mr. Bass. And so there is no question of fact with respect to that. Really what we're looking at is a technical argument that Mr. Nagy believes that the only recourse against Mr. Pike is that of an unlawful detainer action. I've been doing this a long time. Courts have applied both ejectment, and I use it in the context of a post-foreclosure eviction, because it's never clear under what authority or what right a person occupying a property is. He could have been a squatter for all I know. That's why we send a notice to vacate that informs them, here's the new owner. If you're there under a lease, send the new owner your lease. If you think you're protected, send the new owner proof of that. And more importantly, notice to vacate is very clear. In order for us to determine on behalf of the property owner, the new owner, what your rights you may have under the Protecting a Tenant Foreclosure Act, you must do the following. Mr. Pike didn't do any. He moves down to the next paragraph. If you're determined to be a bona fide tenant with an expired lease, the property owner, the new owner, identified in the previous paragraph, provides notice that your right to remain in the property expires no later than 90 calendar days. And then the next paragraph tells them if you're there in an unexpired lease, you need to make rent payments. Mr. Nagy wants to extract one paragraph and say, well, we complied with that, but, don't pay attention to the rest. The letter read in its entirety informed Mr. Pike that the property was foreclosed, that there is a new owner, that he has protections under the Protecting Tenants of Foreclosure Act, but in order to evaluate that, in order to determine what those protections might be, here's what you need to do. He did not do any of those. And instead wants to argue, well, I just kept doing what I was doing before. I kept paying the old owner, Mr. Bass, even though I was informed that a property went to sale. Maybe I was legally mistaken. Those ultimately aren't defenses. Lastly, Your Honor, with respect to the Unlawful Detainer Act, if that's the way Mr. Nagy wants to go, Idaho Code Section 6-315 provides that when the evidence that a defendant is guilty of unlawful detainer for grounds not pled in the complaint is presented, the quote, the judge must order that such complaint be forthwith amended to conform with such proofs without any imposition of terms. No continuance shall be permitted upon account for such amendment unless the defendant by affidavit filed shows to the satisfaction of the court good cause therefore. The purpose of that statutory provision is similar to this. I'm trying to evict a tenant on ground A, but turns out when we get to trial, ground A is an illegal basis, but he's also in violation for other grounds. The Unlawful Detainer Action was meant for expedited proceedings to evict occupants. We did not proceed under the Unlawful Detainer Act, again, because this is in a post-foreclosure eviction action. That, to the benefit of Mr. Bass and Mr. Pike, has afforded them 7 months of continued occupation of this property, as opposed to 14 days, which is how quickly an Unlawful Detainer Action could have been pursued and presented. So, at the end of the day, just to summarize real quickly, Your Honor, Mr. Bass is not entitled to continued possession of the property. His interest in the property was terminated as a result of the trustee's sale. There's been no showing of any statutory or procedural irregularity or noncompliance with the Trustees Act. Mr. Pike, he wants to occupy the property pursuant to a lease. He needs to prove he's in compliance with the lease. He admits he is not. The fact that he made a legal mistake as to who he should pay does not create an issue of material fact that he has not paid, continues to not pay my client, and therefore is not in compliance with the lease. And as such, we seek ejectment to have both of those individuals removed from the property so that my client can take possession. Thank you.
All right. Thank you all. Court's going to take this matter under advisement, and I'm going to issue a written decision in due course. I will try to, I can't give you a date on when that will be issued, but I'll try to get that out when I can. Anything further on this matter today?
Not from plaintiff, Your Honor.
Nothing further, Your Honor. Thank you for your time.
I believe I'm not allowed to say anything else, so thank you, Your Honor.
All right. We don't have anything else set in this matter at this time. Depending on the outcome of my decision, if I deny the motion for summary judgment on either party, we'll set this matter for a status conference at that point, or a scheduling conference. All right. With that, have a great day. We'll see you all again.
Thank you, Your Honor.
Thank you. We'll be in recess.
Today is 2024, 10th October 22, and it is now 10:56 a.m. Pacific Standard Time. I'm Jeremy Bass, 31782. That was the court hearing with Honorable Judge Evans, and so other parties already named.